I call David Clendon.
Yeah, thank you, Mr Speaker. I'm pleased to be able to speak to this bill, the Substance Addiction Compulsory Assessment and Treatment Bill. It's one I haven't been actively engaged with particularly. It went, of course, to the Health Select Committee, which was appropriate for a bill of this nature. But my interest has certainly been to the extent that I look at justice issues for the Greens. And obviously, when we're talking about compulsory detention and treatment, there are significant human rights issues involved. And for that reason, I have sort of tracked the progress of this bill with some interest. And I have no doubt that our former colleague and friend Kevin Haig would have made a very useful and positive contribution as this bill proceeded through the Health Select Committee. The bill, I thought, had been around a long time. Actually, it hasn't been excessively slow. It was introduced in December 15. First reading of March last year. The Select Committee had a good go at it. So it was about 6 months coming back from Select Committee, and that's not inappropriate for a bill of this significance, I think. What's blindingly obvious, of course, is that the existing legislation that this bill replaces was seriously out of date. It was 1966 legislation, and there was a broad and deep agreement that that legislation is no longer fit for purpose. So, among other things, it enabled the committal, effectively the detention of people for compulsory treatment on the say-so of 2 medical practitioners, but neither of those 2 practitioners was obliged to have any sort of specialist knowledge or experience as drug practitioners, and that was seen as an obvious flaw in this. It's a highly specialised area of treatment and medicine, I guess, and it's appropriate that the new bill does put that right. So in future there will be required that at least one of the medical officers will be a specialist in this area, a practitioner in this area. The 1966 legislation allowed for a 2-year committal of a person, which we know by modern standards is far excessive and far in excess of what is reasonable. These are very acute conditions we're dealing with, people who are unable to make decisions on their own behalf. Those sorts of conditions ought not to be prolonged, and certainly it would be unusual for somebody to retain in that situation for a period of 2 years. The legislation, I believe, now talks about an initial period of some 8 weeks, and that's a much more appropriate period of time. Again, the 66 legislation required a court process, which is somewhat cumbersome, slow, and often quite daunting for people who are already in an unhappy situation of needing potentially to deprive somebody of their freedom of choice. And it's unhelpful in these, as I say, these very urgent, acute situations if there is a slow and protracted court process. And again, this legislation does away for that. And overwhelmingly, the feedback that came from particularly from the submitters to the Select Committee, is that there were insufficient, inadequate safeguards for the people who might be subject to this sort of legislation in terms of protecting human rights, protecting their well-being. I guess it reflects sort of cultural norms in 1966. The world has moved on since then in all sorts of ways, culturally, and in other ways we are now perhaps a little more enlightened in our understanding that these people actually are, in their own way, they're victims of they have a health condition. They're not necessarily criminal people, though, of course, sadly, drug addiction is often also a driver of criminal offending. But inherently or substantially, we're wanting to move away from the notion that you're dealing with criminals. We are dealing with people who have severe health problems, and the new legislation does recognise that. So I mentioned some of the submitters, CADS, the Community Alcohol and Drug Service, made some very useful contributions in submitting on this bill from a very informed position. They are day-to-day engaging with these people, and I have to say that I have the greatest respect and regard for people who work in the area of addiction, because they are seeing people and dealing with people who are at their worst, frankly. People in conditions that for a lot of us would be very easy to dismiss or write off, frankly. Personally, I think I would struggle to engage with some of these people. They're in a dreadful situation, and I do really respect the work that's done by these various agencies who see through that, who just see a human being in need and seek to provide some service to them. So the legislation, as I said, has had a fairly rigorous attention, I think, from the Select Committee. It had a lot of submitters, as I've said. CADs were in there, organisations like Just Speak and the Wellington Justice Project. A lot of the DHB submitted, various other entities and organisations, large and small, the Privacy Commissioner. And that's appropriate, that there should be broad and deep submissions to this legislation, because on the face of it, it is actually quite draconian legislation. It is the state saying to a person, you're not fit to make decisions on your own behalf, and therefore we are going to detain you and subject you to compulsory treatment. That's fairly heavy-handed, but it also, sadly, is necessary. What I particularly like about this legislation, it is draconian, it is heavy-handed, but it has a very clear statement of purpose. And that is one of the primary defences, I think, of human rights in this bill, that the purpose of the bill very clearly states the primary purpose in this sense is to protect people from harm. And that's a very significant sort of a stake in the ground to say that is the key outcome we're looking for, is to protect this person or these people from harm. It's supposed, again, the purpose goes on to say it's to facilitate a comprehensive assessment of their addiction. So to have a very, very clear understanding of the nature of the addiction, what are you dealing with in terms of this person or the health status of these people. The bill, the legislation, the process rather, the compulsory treatment is intended to stabilise their health. Clearly the focus is very much on working out how do we get these people back to a situation as swiftly as possible and as timely a way as possible so that they can then take responsibility for themselves and ideally then morph away from this compulsory status into a voluntary program. There's a phrase there that protect and enhance their mana and dignity, restore their capacity to make informed decisions about further treatment and substance use. And one would hope that would be a discontinuation of substance use, because that obviously is the end goal for most of these people, to get them away from these very destructive drugs that are doing such terrible things to their health and well-being. So the other approach, if you like, that this bill takes that I particularly admire is that it outlines a set of principles, because you're going to get a lot of different circumstances, a lot of different situations that people are going to be in, and it's very hard to legislate for every particular circumstance or situation that might arise when you've got such a complex area as mental health, well-being, to the point that we're demanding a compulsory treatment. So by establishing a set of principles, I think it's a very powerful model to say, okay, these are the principles that will guide decision-making by practitioners, by decision-makers, and I think it's a very robust and appropriate form of determining exactly how people will be treated, rather than trying to be too prescriptive about it, because prescription typically will fail with the best will in the world. It's hard to imagine 20, 30 years in advance, and that may well be the life of this legislation, what circumstances might occur. The principles are very clearly outlined. I think they're robust. For example, Principle A, where compulsion is necessary, the level of coercion used must always be the least restrictive possible. So we intrude or intervene in a person's life as little as we must do to achieve the ends, the outcomes we're looking for. The views of the patient and the patient's principal caregiver should be ascertained and taken into account. It's a very thoughtful approach. It's one that recognises that while these people temporarily are not in a good situation, not in a position to make decisions about their own treatment or well-being. It gives the maximum scope to engage them and their caregivers in their treatment and in the compulsion. So, sir, I think this is a well thought through bill. It's well framed, and the Greens will be pleased to continue to support it.